Hello and a warm welcome to Federal Special Program Capital Beat. Vice President Jagdeep Dhankhar on Thursday issued a sharp rebuke to the judiciary for overstepping its mandate, specifically questioning recent moves to direct the president on legislative matters. He called Article 142 a nuclear missile in the judiciary's arsenal, which is available to them 24/7. And he actually said, and I'm going to quote him, that you cannot direct the president. The only authority under the Constitution to interpret the law lies with a bench of five or more judges under Article 145.3. Now, this was obviously with regards to the recent order by the Supreme Court in case of Tamil Nadu's governor's case. And then he goes on to say, precedent being called upon to decide in a time bound manner, and if not, it becomes a law. So we have judges who will legislate, who will perform executive functions, who will act as super parliament and absolutely have no accountability because of the law of the land does not apply to them. Now, these comments made by Mr. Jagdeep Dhankhar have drawn sharp reactions from various opposition leaders today. Many of them have tweeted. But the big question which we are going to ask is that and it's not that Dhankar has spoken for the first time like this, but when it comes to judiciary, have these remarks gone totally out of line? Have they been out of the remit and decorum as far as the integrity of the constitutional office is concerned? So we'll try and discuss this. And some people also are reading it as putting judiciary under some kind of a pressure, because just a few days back, even Law Minister Kiran Rijiju was saying a similar thing on a public podium. So we'll try and discuss this. How does one decode Dhankar's comments today? Joining me is former Secretary General of Lok Sabha, PDT Achari. Mr. Achari, thank you so much for joining. And we have political editor of the Federal, Puneet Nicholas Yadav, also joins us. Thank you so much, Puneet, for joining. And I'll begin with Mr. PDT Achari. You yourself have been on a post of a Secretary General. But when you heard Mr. Dhankar's comments, I'm not saying that you make any personal remark against him, but how would you view it in general? Yes, sir.
Well, I have read the Honorable Vice President's comments in the newspapers. He has used very strong words against the judiciary in this particular context. And I do not want to go beyond that. I do not want to make any direct comment on what the Honorable Vice President has said. Vice President has expressed his opinion on the Supreme Court judgment in the Tamil Nadu governor's case. The issue is whether the Supreme Court has overstepped its bounds when it set a timeline, and then the Honorable Vice President particularly referred to Article 142 and called it a nuclear missile or something. Well, 142, we must know that it's an extraordinary provision in the Constitution. And this provision gives extraordinary powers to the Supreme Court for doing complete justice in a matter. That is the purpose, doing complete justice. These are the words which are used in Article 142 by the Constitution. These words, have great meaning. What is complete justice? The job of the judiciary is to do complete justice. That is, in many cases, the executive comes to or ends up doing a lot of injustice to citizens. And they look up to the judiciary to do complete justice. So here the Constitution has emphasized this point, that Supreme Court has the power to do complete justice in any particular case. Therefore, Supreme Court is well within its right to exercise this power. Now, when the court will exercise this power, or in what case or in what matter the court will exercise this power, that is up to the court to decide. But court has this power. So the constitution has given this power to the Supreme Court for obvious purpose, because doing complete justice, is the job of judiciary, and doing justice is at the core of democracy. And therefore, it is actually, this is a measure, this is a power which is given to the apex judiciary. Mind you, this is, Supreme Court alone has this power and no other court. By giving this power to the apex court, the constitution has ensured that people will get complete justice where it is lacking. So that is the purpose of this article. Now, in this particular case, in governor's Tamil Nadu governor's case, the Supreme Court has used this for a specific purpose, and we must understand the context. Only then we will realize the significance of the exercise of this power by the court. 10 bills were passed by the Tamil Nadu Assembly and sent to the governor at different times. It's almost 5 to 6 years. The governor sat on those bills without doing anything, and when there was a hue and cry, he sent it to the president. And president rejected all the bills. Now, in this particular case, what we must seriously think is whether the governor has the power, or governor has the option to sit on a bill for any length of time without taking any decision. That is precisely what the Supreme Court has addressed. That is the core question, which was addressed by the Supreme Court. Now, after that, Supreme Court said, no, not at all. It gave very a landmark decision on the interpretation of Article 200, particularly the second option available to the governor, namely withholding assent. So court has very emphatically said the Supreme Court, the governor has no power. He can withhold assent, but at the same time, he should immediately send it to the assembly for reconsideration. And if the assembly reconsiders it and sends it back to the governor with or without amendments, the governor will have to give assent. This has been made very, very clear. Now, that is a very important decision, important point which has been decided by the Supreme Court. Now, so far as the exercise of Article 142 is concerned, this has been exercised by the Supreme Court for assenting to the bill, disposing of the bills. Now, what are the options before the Supreme Court in this kind of a situation? Should the Supreme Court send it back to the governor, who sat on the bills for over 6 years? Now the Supreme Court found that that was not necessary at all, because nobody knows what the governor will do. And therefore, to do complete justice, Supreme Court invoked the power vested in the Supreme Court under Article 142 and declared that these bills are deemed to have been passed. That is what has happened. So one can, of course, argue that it was not a proper case where the Supreme Court should have done this, etc., etc. That is neither here nor there. The Supreme Court has used this power to do complete justice.
Right. All right. Okay. I'll come to Puneet now. That much has been said on Article 142 and what Dhankar said yesterday. How would you view it politically? Because the technical positioning Mr. Achari has already explained. But there is a view that by making these comments, Dhankar is trying to put judiciary under pressure. He's trying to show them some kind of a mirror. How can you challenge the president? How can you challenge the legislature? That is the tone and the message which has been sent out. How would you read it politically?
Politically, well, Neelu, see, at the outset, one needs to say this. that what the vice president has said is not just unfortunate or uncalled for, but might I add, even perhaps unconstitutional in its uh, spirit, because look at the words that he has used. As Mr. Achari said, very strong words, where he says Article 142 has become a nuclear missile uh, to attack democratic forces with. The vice president, who himself comes with a very illustrious legal background, perhaps would know that Article 142 hasn't come from somewhere else. It comes from the Constitution. Who are you accusing of attacking democracy with a nuclear missile? The judiciary. Does the judiciary function outside the purview of the Constitution? Do the powers that the judiciary uh, draws from Article 142, are they coming from outside the Constitution? So the vice president needs to perhaps reflect on what exactly he's saying, the motivations behind his saying so are a different matter altogether. If I might take you back a little, the thing with the current vice president is that ever since he's assumed office in August 2022, to kind of somehow rein in the judiciary has been his, um, I'd say, an abiding agenda with him. His very first comments, his very first address to Rajya Sabha, uh, after becoming the ex officio chairman of the Rajya Sabha, he spoke at length about the NJAC and how the courts should not have these powers of overriding bills passed by unanimously by Parliament. In the recently concluded session of Parliament, he has reiterated that stand in many different ways. And towards the end of the session, he in fact went to the extent of saying that members of parliament need to reflect on whether constitutional amendments passed by parliament should even be within the purview of the judiciary to examine, you know. So, if there is an unconstitutionality, if there is, one may say, you know, a kind of element here of acting beyond the scope of the Constitution, that is actually being exercised, unfortunately, by the Vice President himself and not by the judiciary. In the case of Tamil Nadu,
Just allow me to interrupt you, Puneet, but can this statement by Mr. Dhankar also can be seen as a contempt to court, because this was an order given by the Supreme Court? Can there be a contempt notice against him? Can the judiciary do that?
that's not something I'm very clear on, Nilu. I'll need to check on that, but I don't think so. But what I would say is, I mean, you have to look at the facts here. This is, of course, not the first time that we've heard such comments from the vice president. I'm afraid this won't be the last time either. He has been prodding. In fact, in the same speech where he talks about Article 142 being a nuclear missile against democratic forces, I believe he's also talked on or reiterated his position that the Constitution, with regard to how the judiciary is exercising its powers, needs to be revisited.
Mhm.
Now, what is the current problem here? He's talking about, can the president of India be given directions? Why can it not be? Why can the president not be given directions? Does the Constitution say that the judiciary cannot give any directions to the president? Secondly, the term of a government is 5 years. Why do we elect governments? Aside from governance, to enact laws for legislative business. If the government cannot do its legislative business, if its legislative agenda is paralyzed by the governor and by extension by the president, who is not returning bills, the governor is not returning the bills, is that constitutional? Can you paralyze the legislative agenda of an elected government? In that scenario, what is the option left? And mind you, Neelu, this is not the first time. It's been made out to be as if this is the first time that the Supreme Court has intervened and made some orders with regard to powers of the governor. This is not the first time. These rulings have come many times by the Supreme Court in how a governor, how the governor, or in the case of Delhi and other union territories, how lieutenant governors have to act. And there have been constitutional bench rulings. The difference perhaps is that those spoke about returning bills within a reasonable time. Now, unfortunately, the reasonable time is a very subjective interpretation for many. We've seen in the speaker's case also, where in the case of Maharashtra, the Supreme Court used the phrase reasonable time. And that reasonable time never seemed to arrive. So what do? You then you're compelled to define a timeline. And that is what has happened. Mr. Achari has explained at length the powers and the scope of Article 142. And this, all I would want to add is that this was a fit case for the Supreme Court to invoke those powers.
Yeah. No, but would you interpret this as some kind of a pressure tactics by Mr. Dhankhar and similarly by Mr. Kiran Rijiju, how he spoke? So are they trying to put pressure on the judiciary? That whenever they see that the judiciary is taking some independent decisions, they will come back with statements like these.
You see, as far as Mr. Rijiju is concerned, as a minister, as a still practicing politician, one may or may not attribute, him asserting pressure on the judiciary or whatever you want to call it. But the fact is that you cannot have these double standards. When the judiciary, and this is true for all politicians, I'm not singling out Mr. Rijiju, even politicians from the opposition are equally guilty of this, that when you have the Supreme Court giving a judgment which is in your favor, the Supreme Court deserves all the laurels and applause. But if there is a judgment that goes against you, suddenly it becomes, open to all kinds of criticism. And that is what the law minister has been doing. The unfortunate part is that the vice president is not supposed to be acting like a politician, but he's unfortunately speaking the same language, I wouldn't just say of BJP ministers, but perhaps people, who peddle BJP agenda on WhatsApp.
Right.
So that's the thing. I mean, whether they're trying to exert pressure or not, I think the best way to understand that is to just read through their speeches. I mean, I'm not going to attribute that to the vice president or the minister himself. But I mean, I think everyone has a fair sense of, interpretation, and you read through their statements and you'll know what it's trying to suggest.
Right. But I'll come back with the same question to Mr. Achari, that Mr. Achari, if a vice president of India who's a Rajya Sabha chairman and makes a comment like this on the judiciary, and especially coming as it does immediately after an order which came recently by the Supreme Court, can the Supreme Court, under its special powers, send a contempt notice to the vice president?
No, actually, so far as the aspect of contempt is concerned, I have my own doubts, because contempt happens when you criticize a judge personally and find it's a personal kind of attack on a judge. Perhaps that may amount to contempt, but you can always analyze a judgment. A judgment is a public property, and it can be analyzed and it can be commented upon. You can criticize it, you can applaud it, all that you can do, but that doesn't amount to contempt. That's it.
Right. Okay. But Mr. Achari, to you only, that the kind of comments which have been made by Mr. Dhankar, what could be the impact on the judiciary? How would the judiciary take it? These comments.
I don't think it will have any impact on the judiciary as such, because judiciary, the Indian judiciary has not started yesterday or day before yesterday. It has been there for a long time. It has a long history. And I must also say one thing, that it is not the first time that the political executive or the politicians speak against the judiciary. They have been doing it. The whole point is the politicians, they want to appropriate all the powers. So kind of a hegemonic attitude of mind. And when judiciary steps in and strikes down certain actions of the executive, naturally the executive will be very angry. This I have seen many times in the past. I spent 40 years in the parliament, and during that period, on many occasions I have seen this, particularly before the emergency and during emergency, of course. A lot of changes were brought into the constitution, which would have made the executive totally unassailable and all that. But that has changed later. That was changed later when the Janata Party came to power. That is all part of history. The point is that the politicians never wholeheartedly approve what the judiciary is doing. They always have a grievance that judiciary is overreaching. Now, what can you say? In fact, in my opinion, it is actually the judiciary which has saved the Constitution of India. In Keshavananda Bharati, they came up with the famous doctrine of basic structure and said Parliament has the power to amend the Constitution, any part of the Constitution, including the fundamental rights. But while doing so, they should not alter the basic structure of the Constitution. So this doctrine, and they elaborated on this. They listed out certain things, which, for example, democracy, rule of law, independence of judiciary. These are all a republican form of government. These are all these are all parts of the basic structure of the Constitution. And that has actually saved the Constitution. Otherwise, the politicians, would have almost finished it. Because if Parliament has the untrammeled power to amend the Constitution, then you can imagine and if it is kept out of bounds for the court, then the Constitution is over. The constitutional system will be over. That is how it is. So politicians will always have a complaint against the judiciary, but that has never impacted the judiciary in its decisions. That is it. Of course, there may be judges who may kind of at some time favor the government or all that sort of thing, it may happen, I do not know. Or people may get an impression that, but that is not how the judiciary functions. Judiciary, I think, functions in an impartial way, and their job is, or their remedy is to provide justice to the people. That is what it is. So we must understand the judiciary's function in this context, in this background, that they have done this by invoking this extraordinary power vested in Article 142 to do complete justice in a particular case. And this is a very deserving case, in my opinion, where the Supreme Court Supreme Court justifiably invoked Article 142 and the power vested in Article 142.
Right. That brings me to the question again, Puneet, that what is the political compulsion of Mr. Jagdeep Dhankhar, why he keeps making comments like these, and to the and going to the extent of now maligning judiciary in a way. And what you initially pointed out, that he himself is an illustrious lawyer, that in fact has been pointed out by Mr. Kapil Sibal also, that he doesn't know that the constitution only has given the right of Article 142 to the Supreme Court judges, and does he not know that? So what that brings me to the last question, that what is the political compulsion? What does he benefit when he makes statements like these? Many people say, oh, he wants to become the president of India, he wants to gain better brownie points with the ruling dispensation, but he does it at a big cost. So what is the ultimate benefit he's getting out of it?
No, well, that is not for me to comment on, Neelu, and it would be very irresponsible for us to be, saying something like that. If it was just an individual named Mr. Jagdeep Dhankar, one could have, risked taking those guesses. But he holds the office of the vice president. We do not cast aspersions on the office of the vice president. But having said that, I would, of course, say that a lot of what he says, the statements that he makes, whether it's with regard to the judiciary or on issues which are not exactly issues on which the vice president or should be speaking on, a lot of those statements uh, resemble, or rather seem to sound uh, straight out of what you hear from people from the ruling dispensation. It's exactly the same kind of views that are shared, and the same kind of attacks at the judiciary, the same kind of talk of changing the constitution when needed, if needed. We've heard that come very frequently from people in the BJP. It's unfortunate, as I said earlier, that the vice president is unable to differentiate between a political statement and a statement that befits the office that he holds, and he ends up making statements that are blatantly, brazenly partisan, political in nature, and should not be made by a person holding the office that he is currently holding.
Well, what does one say beyond this? But we'll have to end it here. Thank you so much, Mr. PDT Achari. Puneet, thank you very much for joining. Thank you.
Sure.
Thank you, sir.